Welcome to the P3 Project for Diverse Entrepreneurs podcast, where we explore the people, policies, and opportunities shaping the future of diverse business. I'm your host, Shelton Russell. In today's episode, I am joined by one of the nation's foremost authorities on supplier diversity and government contracting, attorney Colette Holt of Colette Holt Associates. Together, we discussed the sweeping changes to the U.S. Department of Transportation's DBE program, the new Interim Final Rule, and the future of supplier diversity, and what DBEs, prime contractors, and public agencies need to know in this rapidly changing legal environment. Let's get started. Hey, good afternoon, Colette. Good to see you today.
Good afternoon to you, Shelton. It's always good to be with you.
But today I'm pleased to welcome Colette Holt, one of the nation's leading civil rights attorneys and consultants in government contracting and on business diversity programs, including the Federal Disadvantaged Business Enterprise Program. For decades, she has advised federal, state, and local governments, transit agencies, airports, and private organizations on developing legally defensible diversity programs while helping organizations navigate an evolving legal landscape. Thank you for joining us today, Colette. To begin, I gave a brief introduction, but tell us a little more about Colette Holt and your work.
Well, I'm happy to do that, but I also want to be sure that we talk about some of the substance. As you said, I've been involved in these issues for decades now. Started out as an assistant corporation counsel for the city of Chicago. I've had my own firm now since 1994, so I guess it's no longer an experiment. And that's what we focus on. I've devoted my professional life to supporting and helping and drafting programs to help minority and women-owned businesses, and do a lot of expert witness work. We were just chatting a little bit before we got on about how kind of crazy I am right now because I have 2 expert witness reports due in 2 cases next week. But anyway, so that's what I do, and I've been working a lot, of course, on the DBE program, been involved since the very beginning when we got the new regulations at 49 CFR Part 26 in 1999. And I met you when you were running the Civil Rights Department at North Carolina DOT. So I know that you know a huge amount about this. And I'm just so delighted that American DBE Magazine is out there with your site and everything else, because it can be difficult to get accurate information about these programs. And so I'm always happy to submit articles to you to try to keep people educated and informed about what's going on.
Well, thank you, Colette. And I'll correct you. We actually met in the 90s. I was working with the city of Columbus, and you worked with Melinda Carter, right. And you came and did a talk. Right. And I think it was a first disparity study or looking at doing the study. Yeah, back in around 98. 97, 98.
Oh, yes, I think that's exactly right. Oh, dear. Well, I guess we are now OGs officially.
Absolutely. So today we want to do 4 things. We want to really explain the recent legal developments affecting the program, the DBE program, help listeners understand the USDOT Interim Final Rule a little better, or as it is progressing out in different states. Talk about some practical guidance for the DBEs and ACDBEs out there, prime contractors and agencies who all are looking to navigate this time. And then finally, kind of look at where we're going with some of these programs in the future. So let's start by saying, since we talked a few months ago, right after the Interim Final Rule came out, since then we've seen some other decisions and executive actions, agency responses to the new Interim Final Rule. So from your perspective, what are the most significant legal developments that DBEs, prime contractors, and agencies should understand?
Well, certainly the Interim Final Rule from USDOT that amends the regulations that govern the program at 49 CFR Part 26 are really critical. I think what people need to understand is that the focus of these programs is being changed really unilaterally, at least at the DBE program, by the federal government, by the Trump administration. The Interim Final Rule changes the program from a remedial program designed to address identified discrimination in the market for federal transportation contracts on the basis of race and gender. Now the program is this sort of, I guess, inchoate idea of disadvantage some kind of way. And now these are an individual requirements and an individual exploration of that particular applicant's background, history, and barriers that people may have faced in attempting to do business. So at least in my view, this is a radical rewriting of both Congress's intent and the overall objective of the program. Everything is now supposed to be quote unquote race neutral, and there's no more idea of systemic discrimination that ties this all together. So that is a radical change in the program. And so where we are with the interim final rule now is all certified DBEs who want to stay in the program have to submit an individual narrative, an updated personal net worth statement, and that individual narrative needs to describe your experiences as a business owner and the barriers that you may have faced, but you cannot mention race or gender. So you end up in this sort of odd kind of purgatory almost, or space where you're supposed to not talk about the thing that the program is designed to address, but still somehow explain how you're disadvantaged. So I'll give you an example of one of the very earliest questions that I got was from a woman who was a DBE. And she said that when she first started her company, the project managers, the superintendent on the job site, would expose himself to her. And she said, how am I supposed to talk about that without mentioning it was a man? Well, I said, well, how about this? It will be linguistically very awkward, but just keep referring to this individual, this person, the superintendent. And I guess people would figure out that it was really was a sexual advance or something that you experienced because you were a woman, but you didn't say that. One of the things I do want your DBE listeners, those of you who are certified who have not submitted, is that most of the agencies are approving most of the applications that they get. So the approval rate is really quite high if people will submit. That said, one of the most troubling things is the very low level of participation from DBEs that are already certified. Some of these agencies are only getting 25% of the DBEs submitting their new personal narrative for reevaluation. And so I think without question, the DBE goals are going to go down. The other problem with this is that because there's nothing now that ties all these people together, it's going to be very difficult to define the availability of DBEs as anything other than the firms that are actually certified through the process. I've worked on, 60, 70 disparity studies. And a disparity study is designed to look at the experiences of women and minority firms in the agency's market area. And we gather anecdotal data, we do statistical analysis, but it is all premised on the idea that this is a remedial civil rights program and that we can say something about the experiences of people as members of these disfavored groups. Now the DBE program is, again, as I just this kind of individualized, whatever happened to you, but nothing is tying all these people together. So, the data that I have about, let's pick North Carolina, who I'm going to be working with on this. I can tell you what the availability of women and minority-owned firms in a particular NAICS code is in North Carolina. But what I can't tell you is what the availability is now of DBEs other than the people who have made it through the process. So it really is a truncating of the program in a really very drastic way. So we'll see what happens with this. But so, for example, Michigan, which was one of the very first states to complete the process, has had their goal drop to 5.5%. Let us contemplate for a moment the demographics of the state of Michigan.
Absolutely.
So I think people really need to participate. If you are a DBE and you want to stay in the program, please submit your narrative. I know that everybody had to have kind of a cutoff date in which they said, well, this is the corpus of applications that we're going to look at so that we can get through the process. We can submit to USDOT and we can then sort of restart our program. But they will still accept applications after that date. So please do submit. There are AI tools out there. I'm not endorsing them, but they are out there, and you might try that. I don't know that anybody needs a lawyer to help them write this, unless you have some particularly complicated situation. That's kind of where we stand with that.
Okay, and in the midst of this new interim final rule, the Mid-America Milling versus USDOT case was dismissed, and that seems like a good thing. But tell us what, if any, impact or what impact that has on the program going forward.
Well, it really doesn't have any impact on the program going forward because the case was dismissed as moot. But let's back up a little bit so your listeners know what it is we're talking about. About 2 years ago, I guess it is now, a challenge was filed to the DBE program as it then existed by two white subcontractors who alleged that they were being discriminated against by the existence of the program. And they filed in Kentucky. So sometimes people refer to this now as the Kentucky case. But that was a strategic decision on the part of counsel because the federal circuit that covers Kentucky has already given us an opinion, a federal court decision from an appellate level that had, at least in my view, drastically changed what the law is about these programs and what you need to do in order to support them. So that's my assumption as to why they filed in Kentucky. The court did issue a preliminary injunction, essentially accepting the plaintiff's arguments, saying that you have to have evidence of intentional discrimination by the agency against all of the enumerated groups, that you have to be able to tie any statistical disparities back to that intentional discrimination, all of which, quite frankly, I think is impossible. First of all, I don't know that it's true that the agency itself is discriminating against all of these different groups. So I'm not sure what kind of proof you had. And so I'll put it to you this way. When I was an assistant corporation counsel for the city of Chicago, there was no way we were walking into federal court and go, "Good morning, Your Honor, we discriminate." And it's a trick bag anyway, because if you have that type of evidence, then why isn't the remedy to punish the discriminator? Why is the remedy a program to control the behavior of somebody else? So I think this is all incredibly disingenuous, intellectually disingenuous. But in any event, the federal judge in the Mid-America case did issue a preliminary injunction against the operation of the program. Then along comes the Trump administration and the new IFR, which was effective October 3rd. And so the coalition of DBEs that had intervened in the case in order to defend the program, since of course the Bondi Justice Department wasn't going to do that anymore, did get the case dismissed as moot because the court agreed that all the relief that the plaintiffs were seeking, they now got through the IFR. Okay. So there was no reason to have the case. So I'm happy to take that win. But I don't think people should kid themselves about where the federal courts are going. And sort of on that point, the SBA, Small Business Administration's 8A program, has also been sued now, basically making the same arguments that Congress and the SBA don't have evidence about the specific groups. There's no evidence of intentional discrimination. They didn't try race neutral measures enough. The program has no goals, et cetera, et cetera. Well, taking a cue from the success of the IFR, the SBA has put out a notice of proposed rulemaking to essentially gut the 8A program and turn it from a remedial civil rights program to address race discrimination in federal contracting to this kind of individualized approach. So they figured out a way to sort of keep the statute on the books, but to take it and rework it into something else than what it was designed for. And one of the things to keep in mind about the SBA 8A program is back in January, their SBA issued guidance that said that you could establish that you are the victim of discrimination because of the existence of a civil rights or DEI program. So therefore, turning the existence of a civil rights program into the basis to claim that you've been discriminated against. So it is this absolutely upside down, Alice in Wonderland, through the looking glass situation that we're in.
Going back to these personal narratives that we have to write, and I'm in the midst of writing one as we speak. The states that are moving faster, I was just at the AMAC conference a couple weeks ago and heard a few states talking, and some states are going more in depth with their analysis and kind of review of applications than the initial DBE certification many years ago. So do you see states varying on how they're looking at? I mean, certainly you want to verify that someone is eligible to be. I remember Bob Ashby years ago talking about the purpose of the program or the process was to determine if a person is eligible to be a DBE, not to extract teeth and comb under every rock to make sure, that you get the exact same information from everyone. So all that said, you've got one truck DBEs having to go find, go through all these hoops when they made $1 million at most last year and their net worth is $100,000. I mean, nowhere near the thresholds. That said, are you seeing states take a different approach to these reviews? And what are the best practices there?
Well, we're certainly seeing individual reviewers take different approaches. This is one of the things that's so disturbing about this, is the arbitrariness of it. That I read a narrative, I think it's fine. You read a narrative, you think it isn't, because there are no real standards anymore. And so you're getting wildly varying results, not just between states, but between reviewers. One of the things I have been working with agencies on is looking at the hard ones. Don't send me 3,000 things. I can't do that. I don't have time. But if there's some specific cases that are difficult, we can take a look at that where reasonable people could disagree. So yes, I do. I think that's one of the real problems with this approach, is that by ungluing the eligibility criteria from anything, it becomes just kind of, who thinks what, and I expect a flood of appeals. One thing people need to know is that if you are denied, you do have the right to appeal to USDOT. And at least I know the first couple that have shown up there, the appeals were upheld. So the initial decision not to certify was overturned. I don't know if that trend will continue, but if you do get denied, you certainly can appeal. So people need to keep that in mind. And I think, ultimately at the end of the day, as I've been saying for 35 years at least, these are issues about politics. These are political decisions. And a state that does not want to have a strong DBE program with higher goals is probably going to take a more jaundiced view than a state that does. That's again, and one of the things that's so disturbing about it is it seems arbitrary as to how your application gets treated, what the standards are. I know, Sheldon, you had shared with me some examples where it seemed to me that the certifiers were asking for things way beyond what the regulations require. But it's all kind of vague, and so, maybe they're within their rights to do that.
Understood. So you're working with these types of issues every day. I've got my list of questions here, but I want to make sure we get to what you see as the most pressing information that people out here need to have as they navigate through this process.
Well, certainly from the standpoint of the DBEs, do know that if you do not submit, you will eventually be delisted and maybe decertified. That's not quite clear to me as to whether or not it's really decertification. But there is some old case law out there that says that certification, once conferred, becomes a property interest, which means that it is subject to all of the requirements of due process by which you would deprive someone of their property. So people need to know that if you don't submit, you are going to get delisted. I think the thing that agencies need to keep in mind is that there is the possibility of standing up a small business program. In 49 CFR 26.39 is the small business elements in the DBE program. This section has been in there almost from the beginning. People didn't pay it much attention, but it is there. And if you have an approved DBE program plan, you must have submitted something to USDOT about what small business elements you're going to have. Certainly, this is an opportunity to take a look at that and decide if you would like to have a stronger small business element in the DBE program, which could include setting small business contract goals, which the regs do not give you the authority to do, but which DOT can give you the authority in your approved program plan. So that all sounds kind of complicated and technical, but it will matter. So, for example, Washington State DOT, which has been way ahead of these issues in contrast to most states, already has an approved, FHWA approved federal small business plan. So they are able to set SBE goals on their FHWA funded contracts. And those goals might well turn out to be higher than what a DBE goal would be. So there are some sort of workarounds with it, but it does require the state to get approval to set these kind of contract goals and see what happens. Michigan DOT also has approval to do something similar. My argument is that this is now a completely race and gender neutral method, these small business goals. And so you don't have to have the level of detail that you need if it's a race-conscious program where it has to be narrowly tailored and you have to have statistical evidence and you blah, 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 blah. If it's a small business program, maybe you can kind of do what you want. Couple caveats about that. I got that question yesterday. I would think that you could not set both a DBE and an SBE goal on the same contract. I know you can't do it with some kind of local minority business, women business MWBE program. That's been clear for years. I don't think you can do it on using an SBE goal. And I think that is too complicated and kind of defeats the point. So that is one thing to keep in mind. The other thing I think DBEs need to know is that there is language in the reg that says that the agency is supposed to take appropriate action about DBEs that do not go through the reevaluation process and remain in the program. There's no guidance about what appropriate action means. Zero. And so people are starting to struggle with that. I do know that California put out something to its primes about that. And you asked, what would I want prime contractors to know? Title VI of the 1964 Civil Rights Act is still the law. You cannot discriminate. And if I were a prime contractor, I would be very leery, or at least tread slowly and lightly, about kicking DBEs off of your projects. If the DBE is performing well, no issues, and you're busily invoicing the agency for their work, I would be very cautious about saying, well, we're going to just drop you because you're not certified anymore. Because I think you could be open to a regular old race or sex discrimination claim that they fired me because I'm Black, because you didn't fire any of your white subs, and I was performing well. Then what else would be the reason? So I think the problem about delisted DBEs is going to become more pressing with new contracts. If you were already on a contract prior to October 3rd, there is no more reporting, there are no more requirements, but hopefully you're not going to get booted off the project. Going forward, I think, is when you're going to start to see the truly pernicious effects of this new regulation.
Yeah, the thing that popped in my mind as you were speaking was certainly this has been a political kind of process, strongly driven by politics. In the next era, after this president is gone, and let's say the country right sizes and gets its collective mind together, can we get back or even advance from where we were, or is this the new normal and we might as well lock in and this is it?
Well, that's a really good question. In my view, anyway, the administration is not really the problem. It's the federal courts. We were losing these cases when Biden was president because the federal courts have lurched way to the right on these issues. And so I think it's going to be very difficult to do anything about this until we get a new crop of federal judges. And I think the decisions that the Supreme Court dropped in the last week, because of course it is the end of the term, certainly do not give me any hope that we've got 5 votes on the Supreme Court to uphold a remedial civil rights program. The birthright citizenship case was a bright spot, but the case on the ability of the administration to deport and take away the temporary protected status of the Haitians and Syrians lives in some kind of, I don't mean to be disrespectful, but racial fantasy land. Trump was extremely clear about how he feels about Haitians. Remember, they're eating the cats, they're eating the dogs, they're eating the pets of the people who live there in Springfield, Ohio, which, by the way, my husband and I went there last week we're doing kind of a cross-country trip. And the fact that so many of those people there are either going to get deported or going to live in deep fear is sickening and crazy. So I think this court has decided basically that it is done with trying to do anything about the continuing effects of slavery. Now, the administration, will change, but the federal courts don't move that quickly. Federal judges live a long time. The Federal Court of Appeals judge that I clerked for in Chicago lived to be 95. He died on a Monday, and he was set to hear routine cases that Friday. So he was John Kennedy's last appointment. So they get on and they stay because it's a really good gig.
Right.
I mean, so why not? And so I think people need to get their heads around the fact that this world has changed and the federal courts have changed. And so this wasn't exactly what you asked, but I guess this is kind of where we're going, which is, what should people do? My strong advice to my fellow minority and women-owned business owners is, if you are highly dependent on goals, you need to rethink your business plan and shore up your relationships with your primes, with your agencies. Do your own analysis of your business. Be honest with yourself. Where's my firm weak? What do I need to do to improve? How do I add value to a client or prime contractor, whoever it might be? Because I think the days of contract goals with the kind of strong enforcement that, for example, you get from the state DOTs, at least most of them, or cities like Chicago or Austin, Texas, or whatever. I think that is going to be gone. Yes, I'm certainly advocating that people adopt small business programs. But the thing you have to keep in mind is that the vast, vast, vast majority of firms are small. So I can tell you 3 states I looked at recently. Texas, 99.8% of the firms in the state of Texas would qualify under the SBA size standards. It's 99.8 in Florida. It's 99.6 in Illinois. And this is true all over the country. So if we're going to have a small business program, people need to know that that is a much bigger pool of folks than would have been in the DBE program or an MWB program. Certainly urging my clients that if you're going to adopt an SBE program, that you must have some type of personal net worth test attached to it, that you have to have some kind of economic disadvantage requirement, because otherwise you will just get flooded. And then really, what's the point? Yeah. So I think people need to get themselves ready for this and figure out, what it is that you're going to do in order to remain competitive and to maintain your relationships that you have.
So Colette, here in North Carolina, where I am, the DOT has a small business enterprise program. It is only for prime contracts that are smaller in nature, up to $1 million, which in highway work is very small.
It's nothing.
But yeah. My question, and then there's a net income limit of 1.5 million minus your materials. So, $1.5 to $2 million of revenues. That said, can every state or any agency set the parameters of their small business program based on their market and what they believe? So does it always go to in other states, have you seen it go to the SBA size standard, or are they setting their own limits on how large and then net worth requirements as well?
Well, I'm seeing most people are adopting the SBA size standard. So let me just ask you, Shelton, in the North Carolina program, when you say 1.5 million, is that the size of the contract, or is that supposed to be the revenue of the firm?
Well, to be certified as a SBE, it's 1.5 million in sales minus the cost of your materials for the year. And then the largest contract award is $1 million.
Well, 1.5 million, that is a micro business, micro business, especially if you're talking about doing highway work. So, that is so low, as I would suggest that they would want to raise that. Mm-hmm. I think Washington State is using the SBA size standards. You can, in theory, I suppose, make up your own. I think the problem with that is that in order to not just be completely arbitrary, you would really need data that you had looked at as to what the size of these firms is, blah, blah. And I will tell you right now, there really is no place to go get that. You can look at the Census Bureau's databases like the American Community Survey and the Annual Business Survey, but those are in the aggregate. So they don't necessarily tell you what the right number is supposed to be for anything else. I personally think the easiest thing to do is just use the SBA size standards and use the DOT personal net worth. I know in some of the local programs, they have done something different. So, for example, the city of Chicago, in their construction minority and women business program for their non-federally assisted projects, have adopted 150% of the SBA size standard. It's going kind of the exact opposite of North Carolina, right? But you can get up to 150% of the size standards. And as a result of some litigation, gosh, it's going on 20 years ago now, they adopted a P&W personal net worth that now is significantly higher than what the DOT has. So maybe DOT would approve that if we're just talking about the DBE program for USDOT funded contracts. Maybe they would approve something like that. I don't know. Might be worth a shot. You know, other people have a different view than what I'm about to say, but at least in my view, I think these limits are way too low anyway. You can, especially in flat work, you just can't be that small. You can't bond it. Because, of course, the surety wants you to put up everything you own, including your firstborn child. And if you don't own much, you're not going to be able to bond much. Same thing with construction financing, which can be very difficult to obtain. And I just think that we have kept these firms so small that they didn't really grow into competitors in the marketplace. There's a reason why every disparity study that we've ever done in the transportation realm has the DBEs grouped in certain sub-industries. And even before I've looked at an agency's data, I know what they're going to be. They're going to be in flagging, they're going to be in striping, they're going to be in landscaping, maybe some equipment rental. But the real money in highways is being the primes. And we really haven't done much to move these folks into prime opportunities. So in some ways, one thing that is good about a small business program is because it is race and gender neutral, is that you could have set-asides. You know, like you were talking about North Carolina, you know, $1 million and you have to be an SBE. I'd like to see that more like $10 to $15 million so we could actually get some scale here. But you can do set-asides for small businesses, and you cannot do that on the basis of race. I think that would arguably been illegal since the Croson case in 1989. So, you know, the landscape has shifted significantly. And I just really want to urge people to, you know, don't tell yourself stories about how, oh, and you know, in 2028, this is all going to get fixed. Because I don't think it is, because the courts aren't going anywhere. And that's really our problem. Yep.
So my last question is the surface transportation reauthorization. Is there anything that the DBE community should be concerned about as we go towards a new transportation bill? Or I know it was in the first draft that the DBE program was continued in the first draft, but haven't heard much since then. So just bring us up to date on what you've heard or what we should be aware of.
Well, yes, the reauthorization of the Surface Transportation Act did, much to a bit of my surprise, retain the DBE program. But it retains it as it is in the IFR. And so that is a complete reversal of all the evidence that had been relied upon all these years. And I've been involved in every reauthorization for probably at least the last 25 years. Providing testimony to Congress, et cetera, talking about what we found in disparity studies that establishes that there is still race and sex discrimination operating in the market for federally assisted transportation contracts. The reauthorization bill just sort of dispenses with all that and says, well, now it's the same, individualized approach. So I think people need to know that relief will not be coming through the bill unless the Democrats are able to force through a return to the intent and the focus of the DBE program on ensuring a level playing field for everyone, and that being a minority or woman contractor is something that we can address, the barriers that they face. But, now it's this, as I said before, this just kind of individualized whatever. And if you were kept out of a program because you were a white male, then that is discrimination per se, and that allows you to be in the program that was designed to combat discrimination against people of color and women.
Any final thoughts today?
Well, try not to be discouraged. I mean, I always feel, like the voice of doom and gloom. And I have been saying for this, Shelton, as you know, that for at least the last 3 or 4 years that this was coming, that the courts were changing the test. But I will share this with your listeners. On this cross-country trip that we took last week, where we did go to Springfield and meet Haitian people and eat in a Haitian restaurant, and just to show our support. But we also went to South Carolina, which is where my mother's family is from. And I learned that my grandfather was a leader in the anti-lynching movement in South Carolina from about 1910 to 1950. And I have taken a lot of strength from that, because those people were risking their very lives to combat the systemic racism and discrimination against Black people. So I figure if Grandpapa can do it, and that's my mother back on the wall there, who are we to say that we're going to give up?
Absolutely. That's words to close on. Keep hope alive and keep pushing forward. Yeah. Jesse was my man. So
yeah, well, he was not originally from Chicago. He was originally from North Carolina.
Yeah, exactly.
But of course, was in Chicago all those years. So, but keep informed. That's the other thing I really think. I know people are busy. They're running their businesses. They've got families. They have a million other things to do. But stay informed about what's going on. Read American DBE magazine. Participate in groups like AMAC and COMTO and ASHTO and whatnot, so that you stay up to date on what's going on and take strength from each other.
Absolutely. Thank you for your time today, Colette. I know you've got a lot on the plate, so thank you for breaking out a few moments.
I got 2 extra witness reports to write.
Absolutely.
All right. Good to see you, Shelton.
Right.
Thank you so much for having me. Look forward to the next time.